Hi, everybody. I'm Claudia Bester. I'm the Director of Public Programs here at the Hammer Museum, and welcome to our first Constitution Happy Hour of 2019. We're very excited. We did this in 2017, and it was fabulous, and we've been wanting to bring it back, but the museum has been under construction, so finally we have this great space where we can do it, and we're really happy to bring it back, and hopefully it won't just be the 5 nights that we have programmed between now and December. We'll probably take it into 2020 as well and keep doing it. So what is Constitution Happy Hour? It's kind of like a book club, but we're all reading the book is the United States Constitution. And every week we'll focus on a specific topic within the Constitution, and we will have a discussion led by a scholar who specializes in that aspect of the Constitution. Everybody who came in, hopefully you got your own free paperback copy of the US Constitution. If you did not, raise your hand and an usher can bring you one. We have about 1,500 of them, so don't be shy. So our speaker will talk for 20, 30, maybe 40 minutes, and then lead a discussion with all of you. In the meantime, feel free to order drinks and snacks at the bar. If you come back next week, you're welcome to bring takeout if you want and have a little din-din while we do the Constitution. When we get to the more interactive discussion group, someone will bring you a microphone, so just raise your hand and then someone will bring a microphone to you. And please make sure you do use the microphone because that way everybody can hear you. So My Daily Constitution is a project by the LA-based artist Linda Pollock. Linda, can you wave to the audience? She's back there. Her idea is to bring people together and engage in creative dialogues about democracy and society. Linda first began My Daily Constitution for a 2002 art exhibition called Democracy When? At the Lace Gallery in response to the Patriot Act. Since then, she's initiated Constitution cafes in bars, libraries, cafes, parks, restaurants, churches, and other places where people gather. To quote Linda, "Our Constitution, our democracy is about interpretation. And interpretation means a collective, active dialogue, not just passive consumers and lawmaking producers. The US Constitution is a living document, part of our quotidian life, influencing us in both large and small ways daily." I agree with all of that, and I think it behooves all of us to actually read our own Constitution and learn to interpret it for ourselves and see what it really says about the different subjects. For example, what does it say about treason? Today we're going to talk about treason. So that is the topic of the day. Our guest scholar tonight is Dave Glazier. After graduating from college unsure of exactly what he wanted to do, Dave spent the next 21 years on a grand world tour as a US Navy surface warfare officer, visiting 40 countries and sailing every ocean except the Arctic. He served on 5 different ships, culminating in command of the San Diego-based guided missile frigate USS George Philip. After retiring from the Navy on September 1st, 2001, he earned his law degree from the University of Virginia School of Law, and then spent 2 years as a research fellow at the school's Center for National Security Law, prior to accepting a permanent position at Loyola Law School here in Los Angeles, where his research and teaching focuses on issues of constitutional and intellectual law. He also holds an affiliated appointment in Loyola Marymount University's Political Science Department, where he teaches one dedicated undergraduate course each year. So now please join me in welcoming Dave Glazier.
Thank you very much for that kind introduction. I enjoy teaching both law students and undergrads very much. I fantasize that associating with all those young folks will help me stay young. But the reality is that I'm really thrilled to look around the room tonight and see so many people who are close to my own age, because I am so tired of saying Watergate or Nixon or Vietnam and getting a room full of blank stares like, what is that old guy talking about now? So I presume that were I to mention some of those subjects tonight, I would actually find people in the audience who knew what I was talking about. I'm not that old. Okay, so I do want to start by thanking Linda Pollock, who has had this incredible vision to bring the Constitution to so many people in so many venues. As you heard, she's been doing this since 2002. She's given dozens of events like this all across the country. I'd like to think that as a law professor that somehow in some small way I help people learn about the law, but I think Linda actually has done more, and I think she deserves a lot of appreciation for that. And second, I'd like to thank the Hammer Museum and particularly their very hardworking event staff for putting this together. I'm always in awe when I look at the Hammer Museum calendar online and see just how many events they're juggling and coordinating at the same time. So they really have been a very generous sponsor of this and made this all happen. Now, some of the courses I teach, I like to tell the students when I teach international law or I teach a course on the law of war that these courses are ripped from the headlines, that we're going to be talking about things that they will be reading about in the news over the course of the class. Well, I think we can safely make that claim today. Here are two headlines that appeared just yesterday. So Reuters had a headline which read, "Treason!" exclamation point, "Arrest him!" exclamation point, "The Democratic lawmaker who enrages Donald Trump." And USA Today had a headline which said, "Donald Trump is much worse than Richard Nixon. He may have even committed treason." So I think, right, that this is a fairly timely time to have a discussion about the T word. I find as an academic that there are a lot of words that are tossed out very, very loosely in our society. Things like war crimes and genocide, things that actually have a huge amount of legal significance, and yet nobody cares to actually take the time to learn what those terms mean or how they should be used correctly. And I think just from those two headlines, it's pretty safe to say that treason is in that category as well. In 1833, Supreme Court Justice and Harvard law professor, he managed to hold both those jobs at the same time, Joseph Story, published a very authoritative study on the Constitution called Commentaries on the Constitution. And he cautioned in that study that an accusation of treason is so defamatory that, quote, "whether just or unjust, it subjects him to suspicion and hatred. And in times of high political excitement, acts of a very subordinate nature are often by popular prejudices as well as by royal resentment magnified into this ruinous importance. It's therefore of very great importance that its true nature and limits should be exactly entertained." And that, as I understand it, is my task for tonight, to try to do that for you all. Now, the crime of treason is unique in a number of ways that we'll discuss. But I want to segue into the talk by indicating that one of the things that makes it so unique is that it is the only crime which is actually defined in the Constitution. And that's why this discussion is part of the Constitutional Happy Hour kicking off this series tonight. Now, I realize that a lot of you probably already have a lot of knowledge, and I apologize if I'm telling you things you already know, but I want to try to give a fairly comprehensive presentation to make sure that everybody is on a level playing field when we start the discussion portion in a little while. So, as most of you probably are aware, the Constitution creates two distinct schemes of separation of powers. The first is a horizontal scheme at the national level, where the powers of the federal government are carefully and deliberately divided between three separate branches of government, right? The legislature, the executive, and the judiciary. And the second, and perhaps less focused on many times, is the vertical separation of power between the federal government in Washington and the now 50 state governments throughout the country. We generally use the term federalism to refer to that vertical separation of power. Now, when we turn to the Constitution, the major powers of the government in the Constitution, as well as the limits, are concentrated into the first three articles. Right? Article 1 describes the powers of Congress, the way that it's elected, the way that Congress actually enacts legislation. In that article, the bulk of it actually deals with things like election of congressmen and senators. But to my sense, and for tonight's discussion, the three most important sections are sections 8, 9, and 10. Section 8 describes the powers of Congress. And given that in theory we have a national government which is limited to the enumerated powers, the powers specifically granted to it in the Constitution, Article 8 is arguably the most important part of the Constitution, because essentially what Congress can do is basically what the government as a whole can do. And so again, Section 8 is where we find that. Now, with respect to crimes, since treason ultimately is a crime, in comparison, Article 8 has just a handful of specific powers. First of all, the 6th clause of that article says that Congress can punish the counterfeiting of securities and coins. The 10th clause says that Congress can define and punish piracies, felonies committed on the high seas, and offenses against the law of nations. The 14th clause says that Congress can make rules for the government of the land and naval forces. Today, that takes the form of the Uniform Code of Military Justice, where Congress has actually created a complete criminal code applicable to anyone in the service. To my great dismay, there is a technical provision there which purports to subject retired officers to the Uniform Code of Military Justice. So were I, for example, to say something particularly offensive about the President of the United States tonight, there's an argument that I have committed a crime for which I could be recalled to active duty and court-martialed. So unlike you, I have to be a little bit careful. Also, I would note that in defining the land and naval forces, I think there's a very good argument that the Air Force and Trump's Space Force are unconstitutional. But that would be a good topic for another night. Congress gets to provide for disciplining the militia, so they can make laws for them. They get to exercise exclusive legislation over the National Capital District, which, of course, didn't exist at the time of the Constitution, but the Constitution anticipated the eventual creation of what now we know as Washington, D.C. Now, this is really important because one of the aspects of the vertical separation of powers, or federalism, is that the federal government, in theory, has a very limited ability to enact criminal laws. Right? The states have an almost unlimited ability to criminalize conduct if they think it's necessary for the public welfare, public safety, or public morals, but the federal government doesn't enjoy that kind of power, except with respect to the District of Columbia, where it has exclusive authority. But generally speaking, for Congress to make something a crime, they have to either have specific authority in the Constitution to criminalize that subject, or they have to determine that it is necessary and proper in the execution of another function. Section 9, well, Section 8 is authorities of Congress. Section 9 is limitations on the powers of Congress. So Section 9 says Congress cannot do a number of different specific things. With respect to treason, two of those are very important. One is that Congress can't pass a bill of attainder. Now, I don't know how many folks are actually familiar with the concept of a bill of attainder. It was something that was very common in historical British practice. Essentially, the Parliament would decide for itself whether an individual was guilty of a crime, and if they voted that the individual was, that was a bill of attainder. They could actually have the individual executed. So, anybody want the US Congress to have that authority today, or ever in our history? So the good news is, right, Section 9 categorically prohibits bills of attainder. It also has a prohibition against the enactment of ex post facto laws, meaning that for any of us to be charged or convicted of something as a crime, the crime has to have been defined by statute at the time we engaged in the conduct. So you don't have to worry that you do something today which you believe is legal, Congress passes a law tomorrow making it a crime, and you're then prosecuted for what you did today. You could be prosecuted for what you did on Sunday, but not for what you did on Friday if they enact the law on Saturday. So those, as we'll see in a little bit more detail, are directly relevant to the history of treason that the framers were thinking about when they enacted the specific wording in our Constitution. And then Section 10 is limits on the state. So even though the Constitution is establishing and defining the federal government, it still poses some limits on the state once the federal government came into existence. And again, what's relevant there is that those same two provisions related to bills of attainder and ex post facto laws both apply to state enactments as well as federal. Now that's significant because I'm guessing that most of us are thinking of treason as a federal offense. But most states also have independent statutes which create a crime of treason against the state. And fortunately, those statutes, which could, if unconstrained by the federal Constitution, have the same problems that we'll see were endemic in English law and approach to treason, at least those two protections are going to apply there too. Now, Article 2, defining the executive branch, has one section that might be relevant to our discussion of treason. The final section there, Section 4, deals with impeachment and says that the president, the vice president, and all civil officers can be impeached for treason, bribery, or other high crimes and misdemeanors. Now, when you read about treason historically and internationally, you'll often hear the term high treason used. What high treason means in that context is treason committed against the state. Sometimes they'll use just the plain word treason or even the phrase petty treason to refer to essentially some sort of criminal disloyalty, but to an organization that's lower down the pecking order, or even another private entity. So high treason essentially refers to the crime of treason against the state. It's therefore the opinion of most serious scholars that where the Constitution uses the term high crimes in the impeachment clause, that high has the same meaning. That in other words, a high crime would be a crime against the state, some act of disloyalty or some conduct by an elected official or appointed official that was essentially victimizing the United States or victimizing us collectively as a society. Now, the real heavy lifting, right, with respect to treason is found in the third and final section of Article 3, which creates the federal judiciary. And the words here are on the screen. Obviously, everybody, I'll give you a second to read them for yourself if you haven't already. Great, thank you. Now, interpreting the Constitution is always a bit of a challenge. When I teach constitutional law, I tell my students that we really kind of have to think of the Constitution as a mosaic. There are a lot of words on the page, but we have to look kind of different places, use different means to kind of interpret what they mean. So obviously we start just by reading the text, right? And there are many elements in the text of the Constitution that, just on their face, we understand them. When the Constitution, for example, says that every state gets 2 senators, the plain language is obviously perfectly adequate, and any one of us can tell what that's going to mean. But there are other phrases that may be what we lawyers refer to as terms of art terms that actually have specific legal meaning, and if you don't have some insight into how the term is used in the legal context, you may not be able to figure out exactly what's intended. Sometimes we have to look to the history of the document, including the history of the debates at the Constitutional Congress in the summer of 1787 to understand what they mean. Sometimes there are Supreme Court decisions that have definitively interpreted parts of the Constitution. So there's no single right answer as to how to understand it. It really requires sort of a combination of tools and experience. So what I would like to do this evening, this clause, by the way, though, was actually one that was fairly significantly debated, and many of the words were changed, and in some cases actually changed back during that summer. And so we do have available to us at least some relevant, what we're going to call legislative history, covering that, as well, again, as a lot of knowledge of what England did, because obviously the framers were totally aware of British treason law. They had to be, right? Because everybody who signed the Declaration of Independence committed treason against the crown. So if there was one thing that you can bet they paid attention to, it was the definition of treason. And if anybody is aware of how Britain executed people who committed treason, my God, you had incentive to pay attention. If you don't know, go look it up on Wikipedia or something when you get home. It's too gruesome for me to describe myself. So, first thing to note, treason against the United States. When this was first debated, it read the United States or any one of them. And that was amended during the Congress to strike out or any one of them. So the federal treason law applies only to treason against the federal government, and for that reason, as I alluded to earlier, most states continue to this day to have treason statutes which refer to a treason against the individual states. So if you were to take up arms against the state of California without trying to have California secede from the Union, simply because you didn't like the current governor or something, that would not actually constitute treason under federal law, but would potentially under California law. Now, treason, then it goes on to say, shall consist only in levying war against them or adhering to their enemies, giving them aid and comfort. Now, that only is pretty important, because under British law that was first enacted in the reign of Edward I in the year 1350, there were 7 separate things that could constitute high treason. First, compassing or imagining the death of the king, queen, or their son or heir. Now, the law was not quite as bad as that sounds, compassing or imagining, because there were 2 things required to convict. First, you had to intend the death for treasonous purposes, and second, you actually had to do some overt act towards producing it. Now that might be a very simple thing, like meeting together with some people to plan it, or procuring weapons or explosives or something, but just saying to somebody, I sure wish the king was dead, would not qualify as treason. The second, and somewhat bizarre, thing was violating the king's companion, eldest daughter, or the wife of their heir. Now, the reason for that was because of the risk that the bloodline would be contaminated, right? And somebody would potentially be in line of succession who wasn't actually the legal offspring of the king. So it didn't matter if you violated the king or if you violated the king's male heir. It was only if you violated women who were in a position to give birth to someone who would be in line of succession. The third, levying war against the king. That should sound pretty significant, right? Because in that day and age, the sovereign personified the state. And so when we say levying war against the king, we're also meaning levying war against the state. Fourth, adhering to the king's enemies, giving aid or comfort to them. Okay. Fifth, counterfeiting the king's official seals. Sixth, counterfeiting state currency. And seventh, slaying the chancellor, treasurer, or royal judges. So you actually had to kill one of them to be treason. It wasn't enough just to attempt to or imagine in their death. Now, this was punishable by hanging, drawing, and quartering, unless you were a real elite, in which case they mercifully beheaded you. In 1814, they benevolently changed the law so that you would be hung until you were dead and then drawn and quartered after you were dead. But until then, you were drawn and quartered alive. Now, that actually required disrobing the individual in order to cut them apart. So women, mercifully, well, not mercifully, originally, were burned at the stake because you couldn't publicly disrobe a woman on part of the state. That would be too far beyond the pale. But in 1790, again, they benevolently changed the law so women would just be hung from that point forward. So we see that this language about levying war or adhering to their enemies actually has roots going all the way back into the 14th century. And what the framers are doing here is they are simply making it clear that we are adopting only 2 of the 5 forms of treason that Britain had statutorily enacted and maintained going forward. Now, it's also important because, well, Britain seemed to have the high road in terms of having the statute with these clear definitions. The reality is that British treason practice was much less principled over time. So first of all, in the British common law system, where judges were actually allowed to make law, and they actually had crimes that were not codified, for which you could still be punished and convicted, treason had at sometimes been one of those crimes. What was allowed for much of British history, trying to be a little bit more sophisticated, was we won't allow individual judges to decide exactly what's treason. If a case is brought before a judge that smells sort of like treason but doesn't fit one of those 7 definitions, Britain allowed the judge to pause the trial and send a request to the King and Parliament that they consider the facts and decide whether or not it was treason. And they could essentially, mid-case, establish new law, make something that had already happened treason, and then the judge would go ahead, complete the trial, and the individual could be executed. Second, Parliament preserved those 7 core definitions of treason from 1350 onward, but over time they added and subtracted others on top of that 7. So for much of relatively modern British history, and by relatively modern I mean modern to the framers at the time of the Constitution, other things that constituted treason included a woman marrying the king without disclosing that she had lost her virginity already, marrying any member of the royal family without the king's permission, insulting the king in public or in writing. If a Catholic priest visited England for more than 3 days without converting to the Church of England, that was treason, and they faced a horrific death. Or if any native English national converted to Catholicism, that was treason, and again, they faced a very horrible death. It was also British practice through much of that time to torture individuals who were suspected of treason to try to produce confessions, and they were very lax. British law actually did require 2 witnesses, as we see in the second paragraph here that Congress specified, or specified in the Constitution for the American version, but they played very fast and loose with this. It wasn't actually necessary in many trials to produce either of the witnesses in court, for example. You could just produce hearsay statements from them. And in some cases, one individual testified that the individual had committed treason, and the second person was allowed to testify that they'd heard the first person say that the person committed treason. So essentially, you really just had one witness and a second guy saying what the first witness had told them, which was not very good, right? And so at least the framers were intending to wipe out those practices by requiring two actual witnesses who were competent to testify under American law and met all of the requirements like not being hearsay. And second, maybe you were mistreated or given some false promises or inducement to confess, but they weren't going to be able to admit your confession. You were going to have to actually stand before the judge, having sworn to tell the truth, and testify in open court that you were in fact guilty and had committed the charged conduct. So that was important. Now, what is levying war? Well, levying war requires actual action of some sort against the government in a military or forceful context. Now, it doesn't actually require the resort to violence, but it at a minimum requires assembly of force. It's not sufficient, for example, to recruit people to fight against the US government. That won't constitute treason because it doesn't get to the level of levying war. Adhering to their enemies and aid and comfort, those go together. In other words, you have to both express an intent to engage in disloyal conduct in favor of an adversary, and you have to actually do something that provides some form of assistance, the aid and comfort part, to the enemy. So it's not just enough to speak disloyally or traitorously. You have to have both the intent you have to have the sentiment, and you have to actually commit some sort of overt act, to which, again, you can see from the next sentence, next part of it, you have to have two witnesses to that act. Now, when we look at the final clause here, we see Congress has the power to declare the punishment of treason. When we looked at the powers in Article 1, Congress had the power to actually define the criminal conduct. But here, the framers have taken that authority away from Congress by defining what constitutes the crime here in the Constitution, and all Congress gets to do is enact a statute which says what the penalty will be. Since the founding, there has been the death penalty available for treason. It has actually very rarely been employed. The current statute today, I believe, has a minimum 5-year sentence and $10,000 fine, all the way up to death. But there is a wide range of penalties available. Congress has made that decision. Now, corruption of blood was the British practice by which an individual who engaged in treason lost all of their rights to pass anything down to their family, whether it be some sort of property, which we normally think of an inheritance, or any kind of right or privilege. Now, how extreme was this? Let's say that we have a wealthy grandfather who has a lot of assets that they would like to pass down to their family. The son commits an act of treason. They're tried and executed. The grandchildren completely lose all legal authority to inherit anything from the family, because inheritance from the grandfather to the grandkids would pass through the father or the father's lineage if they were dead. And so it was that comprehensive stripping, really multi-generational penalties. And so the framers were determined that only an individual who commits treason is to suffer for it. There isn't to be any consequences to their extended family as a result. So that is a nice protection in the law. Now, the current statute is found at Title 18 of U.S. Code, Article 2381, and says, whoever owing allegiance to the United States levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere is guilty of treason shall suffer death or be imprisoned not less than 5 years, fined not less than $10,000, and be incapable of holding any office under the United States. So there's a disenfranchisement there. Okay, what's important there is the owing allegiance. Now, it's not mentioned in the Constitution because this was written by people who really understood treason, and it was just kind of a duh to them that the crime of treason was one of disloyalty. But it is probably not, really well thought out as to what owing loyalty means. So obviously, if you're a citizen or national of the United States and you engage in disloyal conduct, which meets this test, you're going to qualify. And it won't matter where in the world you engage in that conduct. But if you are a foreigner who is simply present in the United States, while you are present, you are considered to enjoy the protections of U.S. law, and in exchange for those protections, you owe a temporary duty of loyalty to the United States. So any person present legally in the United States can be convicted of treason if they engage in disloyalty here. Or anyone who has a home here, even if they step outside the United States, can potentially be convicted of treason because they're taking advantage of protections of U.S. law in ordering their lives, and therefore they take on a temporary duty of loyalty to the country. Now, I want to go a few more minutes. Just kind of want to highlight a couple examples. What's actually happened in the United States with treason since the Constitution was enacted? Well, in many ways, maybe the most famous treason case is that of Aaron Burr, who was actually the Vice President of the United States, then dueled with Alexander Hamilton, of course. Hamilton was much more popular than Burr, so Burr really became an outcast as a result of having killed Hamilton. Burr became an outcast having killed Hamilton and having not been prosecuted for it. And so he decided he better just get the heck away from most of American civilization for his own safety, went out to the southwestern frontier, and began engaging in schemes basically intended to take advantage of the fact that he thought at some point there would be conflict involving Spain and or Mexico, and that he could scarf up land cheaply. Jefferson, however, hated him, and so launched what most scholars, I think, agree was sort of a politically motivated effort to convict him of treason. He was actually prosecuted multiple times, which isn't supposed to happen, but he was tried and acquitted very quickly a couple times out in the frontier by local courts, and then somehow the Jefferson administration actually got him into a regular federal district court in Richmond, where his most famous trial took place. And the judge looked at the facts and said, we don't even have witnesses that are willing to testify to the fact that he's committed an act of treason, and so by the constitutional and statutory definitions, he must be acquitted. So it was not even a close thing in the end. So he got off. Another very famous but also very unique case is that of John Brown. Remember the abolitionist who ended up conducting a raid against the federal arsenal at Harper's Ferry, Virginia, a raid that ended up being suppressed by the United States military. And yet, for some reason, he actually ended up in a Virginia state court and was tried and hung for treason against the state of Virginia under Virginia law rather than under federal law, even though obviously raiding a National Guard armory would seem to qualify against the federal government. I haven't been able to find out why that happened. Maybe somebody here knows. In the World War II time frame, we did see multiple different treason prosecutions. So first of all, something that I've spent a lot of time looking at, because I've done a lot of work on the Guantanamo military commissions, was the actions of the 8 Nazi saboteurs who landed by U-boat in 1942, 4 down in Florida, 4 up on Long Island. And that situation and the eventual decision by the Attorney General and the President to prosecute them before military commission established a lot of curious precedents or models for what the Bush administration and subsequently Obama has done down at Guantanamo. But what's much less well known is after those saboteurs were rounded up, tried, and executed, a number of members of their families were then rounded up and prosecuted for treason. And 2 of those cases ended up reaching the Supreme Court. So the first case was known as Kramer versus United States. Kramer had been a longtime friend of one of the saboteurs before they went back to Germany, got their training, and came back to the US by U-boat. In 1942, there was no interchange between the US and Germany. We were in the midst of a very, very brutal war. So when your friend who you know is in Germany suddenly shows up on your doorstep in the United States, right, you know something is going on. And Kramer joked with his friend that, oh, you must have come over on a German submarine. Now, his friend never admitted this, never gave him any information, but did ask him to hold on to several $1,000s. Based on that, he was convicted of treason and sentenced to 45 years in prison. The Supreme Court overturned that conviction by a 4-3 vote. There were 2 vacancies at the time, basically ruling that there was not a sufficient overt act, that simply holding money for someone without the ability to demonstrate that they intended or knew that that money would be used to fund activities harmful to the United States government was not sufficient, and that conviction was overturned. In the second case, the father of one of the Nazi saboteurs, and this is a little ironic because the saboteur in this case was believed to be a lot more serious than some of the others. He helped his son also showed up back in the United States. The father, again, knew he'd been in Germany and so had to know that something very funny was going on here. And his son asked him to help him get employment at a defense contractor and to buy a car at a time when a lot of Americans didn't have access to cars or couldn't get the sufficient rations for gasoline, so that he could drive around and ultimately engage in acts of sabotage. So he did those things. And in his case, the Supreme Court ended up upholding his conviction by an 8-1 vote on the basis that they believed that those did in fact constitute overt acts providing aid and assistance to an enemy, and that he must have had sufficient knowledge, which the court says can be inferred from the circumstances. So you don't have to have a witness to testify that the individual had been told that sabotage was going to be engaged in. You could basically infer it from the totality of the facts. And so that conviction was upheld. A third case, which was tried right here in Los Angeles, was a guy named Kawakita, a Japanese American whose family had taken him to Japan several years before World War II broke out in order for him to learn about his heritage and culture and ultimately to attend college in Japan. He was there when the war broke out. Because of his essentially native English language skills, he was pressed into service as an interpreter in Japanese prisoners of war camp, holding American soldiers. After the war ended, and he's in Japan and the US military is there, he approaches the military, says, hey, I'm an American, I've been stuck here because of the war, I'd like to go back to the United States. And so they arranged for him to come back to the United States. He's here in Los Angeles, and a former American POW encounters him on the streets, and like, that's the son of a bitch that mistreated us in the camp. Ratted him out to the US government, and he was put on trial for treason and also convicted. Now, his defense was that he had renounced his US nationality. He claimed, while I was in Japan, I was a dual national, I renounced my American nationality, so it was perfectly okay for me to work in a prisoner of war camp, even if I did mistreat some Americans. The Supreme Court wasn't buying that. And I think it was fair because this was a guy who chose to come back to the United States and resume his life as an American, so it kind of lacked credibility that he'd renounced his nationality. But again, it highlights the fact that the government had the burden of establishing that duty of nationality. And the Supreme Court did concede that had he in fact renounced his American nationality, then a conviction treason would not be possible. It was only the fact that they did not accept, based on the facts of the case, that he had renounced his nationality, that the conviction was upheld. There were also very important convictions of Americans who broadcast propaganda, both for Germany and Japan. Don't remember their actual names, but there was a woman who was known colloquially as Axis Sally, who broadcast for Germany, and one known as Tokyo Rose, very famously, who did some broadcasting for the Japanese. Now, what's important here is that there is a general consensus among the courts and scholars that mere words are insufficient for a treason prosecution. But yet, these folks were broadcasters, and the tool of broadcasters are words. And the courts, these didn't reach the Supreme Court, but appellate courts ruled, and the Supreme Court chose to let stand the rulings without comment, that when you are broadcasting for an enemy, those are not mere words. That's an actual act of propaganda intended specifically to strengthen the enemy's cause and weaken your own side, and so that clearly meets the aid and comfort standard. And so those convictions were in fact upheld, and both of those women served time in prison before eventually we kind of forgot about World War II and their sentences were commuted or they were allowed to go free. So just saying I don't like the government or I wish the government was overthrown, that's not going to be sufficient for treason. There has to be an overt act, but if your overt act is actually giving speeches or broadcasting specifically on behalf of the enemy, it appears that in that situation, words will be sufficient. So I hope that this has been enough information to kind of set the stage for some interesting discussion. I'll certainly try to take questions, but I would much rather you guys have the opportunity to share your thoughts and ideas. So just as a quick conclusion, before we start the mics around, want to highlight the fact that treason has always, and still to this day, been a very emotionally charged concept, right? And these are allegations which history tells us we should not just throw out loosely, because just accusing someone, even if not on a legally sound basis, can have real-world consequences. And so it's irresponsible to simply toss out allegations of treason. Second, well, there certainly are a lot of historical examples around the world of the crime of treason really being abused for people going after political opponents. At least as Americans, we can take some comfort in the fact that our Constitution sets a fairly high bar with respect to both the definition of the crime and the burden of proof that has to be met. As we've seen, it's strictly limited to levying war or aiding the enemy. Now, both of these require there to be some sort of hostilities, and an enemy, right? And that's kind of a very important thing to note. That's something that seems to me to be missing from the current allegations, right? Today, I think it's safe to say, whether you like this approach or not, that Congress authorized an armed conflict way back in 2001 against those responsible for the 9/11 attacks and those who aided, harbored, or sheltered them. And that means Al-Qaeda and the Taliban. So I do think today that an American could fairly be convicted of treason for activity in support of one of those two groups. The reality is that Congress has codified so many crimes related to providing material support to terrorism that as a practical matter, there's no need to resort to the treason statute, but it certainly would seem to be legally possible to do so. And what about ISIS? I mean, that gets into a whole nother ball of facts, really, about how that conflict has or has not been authorized, right? President Obama kind of launched that conflict without any particular authorization from Congress. And so is that sufficient to make ISIS, much as most of us detest them, and most Americans, I think a very substantial majority of Americans, favor the United States taking action against ISIS, but it would be a really interesting legal and constitutional question were the United States to endeavor to prosecute someone for treason on the basis of conduct in support of or on behalf of ISIS. And then there is Russia. Now, there may be many Americans who don't like Russia, and we were engaged in an extended so-called Cold War against Russia, but I don't believe the United States has actually been in any form of hostilities against Russia since very early in the 20th century, when we initially opposed the communist takeover. So it seems to me that there is no credible way to contend that any kind of support for Russia can rise to the crime of treason. Now, I'm sure there may be plenty of other laws that you could violate in dealing with Russia, but I would conclude by saying I don't think treason is one of them. So, let me end there.
Thank you, David, for this excellent overview. And now the floor is open, and you'll see that we have a chunk of time to really ask questions, and also just if you want to express your frustration, you're allowed to do so. It doesn't have to be
The talk
pure
wasn't
questions.
that bad, was it?
Oh, no, not towards, wouldn't be frustration towards you. So we'll have people.
Thank you very much.
Does everybody have a constitution? Okay.
Thank you for this. Two quick questions. First, can the testimony be sworn affidavits rather than testimony in open court? And the second question is, when did we stop referring to the United States in the plural, where it says against them, and start referring to it in the singular? Thank you.
To take the second question, I'm not sure. I kind of thought we still refer to it in the plural, but I could very well be missing something there.
The United States is a republic, not are a republic.
Yes. Okay. Yeah. I don't know. Good question. Okay. Yeah. So what I apologize. But I really do. I mean, I have ADD, and I usually manage to hold it together, but I confess in thinking about your second question, it threw me so much that I forget what your first question was.
Sworn affidavit.
Sworn affidavit, yeah, thank you. So you're right, this absolutely does not say, right? It just says the testimony of two witnesses, but that is understood. So one of the challenges about this clause was that, remember, this was written in 1787 as part of the original Constitution at a time 2 years or 3 years before the Bill of Rights had actually been enacted. And so at the time, it was necessary for this to be fairly complete in the minds of the framers, but subsequently it would need to be read in terms of the Bill of Rights as well. And so I think we can safely say that testimony does have to be live testimony. Whether this wording meant that or not, I think it did anyway. But even if it doesn't, I think the confrontation clause in the Bill of Rights would now mandate that these individuals would have to actually appear in person, and that the defendant or the defendant's counsel would have the right to cross-examine them.
Before we go to the next question, I just want to remind everybody that we have free copies of the Constitution. For so those of you who arrived late, please just raise your hand and an usher will bring you one. Also, we really encourage people to share tables with strangers and meet new people, so feel free to join one of the tables if you see an empty chair up front. And we'll be roaming around the room. We'll try and get to everybody, but we'll kind of go back and forth, left to right.
In your discussion of broadcast medium, this is obviously a provocative question, but would Twitter count?
I suppose if you had the requisite intent and were actually aiding or comforting someone, it might. But I have to say, that also, I mean, I'm thinking out loud here. I don't teach a course right now that I could ask that as a final exam question, but I think it would be a great final exam question because I don't think there's a clear right answer. One of the problems is that at least these World War II cases were actually using broadcast media provided and sponsored directly by the states, right? So the government of Germany, the government of Japan actually gave these folks radio microphones in an era in which a private individual would have no means to engage in that kind of communication or dissemination of their ideas. So that, I think, makes it fairly easy. But today, when an individual could simply sit on their computer, their own personal computer, or sit on their cell phone, those communications obviously seem much closer to sort of private utterances. And so I think that they're going to be a much harder case to prosecute, but probably not impossible under the right set of circumstances, but a lot harder to prosecute. Now, I don't know, I'm not going to call you out as to whether there's a Trump accusation in there or not, but I think just the fact that any private individual could access those makes it a lot harder to demonstrate the actual requisite support for the foreign entity.
I'm over here. This is the mouse that roared question, the old Peter Sellers movie. Is the phrase "their enemies" commutative in the sense that while we may not have declared or animosity towards an institution, they have declared themselves enemies of us? Would a person who hands out their literature and promotes them in our country, a citizen here, be then liable to treason, even if the country has never, the national government has never said, oh yeah, then they are our enemy?
That's really a great question because it gets at some of the problematic aspects of the war on terror. And it actually is kind of right in my wheelhouse as a scholar of the Guantanamo military commissions. It really is closely related. So in the year 2000, I was the commanding officer of a United States guided missile frigate. And ended up forward deployed. During that time frame, the USS Cole, Navy destroyer, was struck by a speedboat with terrorist explosives in Yemen. There was nobody on the planet who thought the United States was at war at that point in time. Certainly, nobody in the US military did. The response to that attack was to launch a team of FBI agents to go to Yemen and conduct a criminal investigation. The superiors of the crew were really impressed by some of the heroism exhibited by members of the crew in terms of dealing with the damage and saving the ship from sinking. They wanted to award the crew medals for combat valor. The US government said not only no, but hell no. We're not at war. You can't get a combat medal. You can only get a peacetime recognition for heroism. Now, the US identified an individual who they said was the mastermind. They killed him with a drone. They identified a second individual. He's now the mastermind. They killed him with a drone. They identified a third person as the mastermind. They killed him with a drone. They have an idiot at Guantanamo who was supposed to film the attack but forgot to set his alarm clock and set through it. Now they're trying him for the war crime of being the mastermind of an event that took place in peacetime. You cannot have a war crime without war, but when it's convenient for the government, they suddenly make crazy arguments. It's unclear as to whether when this trial finally happens, and it's been years delay, it's unclear, what will actually happen on appeal. The defense has tried to petition U.S. courts to stop the trial before it starts on the basis of you cannot do a war crimes trial when at a time we're not at war, but the U.S. government is retroactively trying to say, oh, well, Al-Qaeda declared war against us back in 1998, so we can do this. Now what, pardon my language, but bullshit, right? since when does a terrorist group or some other piddly little non-state actor get to declare war against a state and have it legally, binding? But we're doing it. Ex post facto creation of war in order to conduct this prosecution. So this has been a very long answer for which I apologize, but it highlights the fact that who knows what the government will actually do, right? And in a situation like that, the government might try to argue, if it saw some practical advantage, that this was in fact a war, and now we can either prosecute you as a war crime or we can bring the treason statute into play. I don't think it would be very credible, but on the other hand, that has not stopped us in the past decade, so it could happen going forward.
Okay, I'm over here. Thank you very much. Right here. Maybe this question arises from my having a very fuzzy sense of what you call terms of art, or even a fuzzy sense of what, say, the Trump administration and the Obama administration have done about whistleblowers. Treason against the United States. It doesn't say treason against a government official. It doesn't say treason against a president. It doesn't say any of those things. It says against the United States. So at what point is l'État c'est moi, I am the state, take over? Also, you mentioned propaganda, the publication of harmful information that would be considered treasonous. That is some aiding an attack or against the United States. Propaganda versus truth. Let's say the Guardian is publishing articles all the time that are disclosing of information that is harmful to individuals within the United States government. They're criticizing. They're saying, hey, look, you guys did this and you're not supposed to do that. Whistleblowers do that. So how do you sort this stuff out? I mean, if a whistleblower is telling the truth about something an official of the government is doing, is that a crime against the state, or is that a valid attack against a misdeed going on within the government?
So, excellent questions. The irony is, and I thought I was saying about something this earlier in my presentation, you decided it was getting way too long, as it was, but one would almost think that the president was a great scholar of legal history, right, and was aware of the fact that historically treason essentially personified the leader, right, and so many of those instances of things that Britain recognized as treason were things like insulting the person of the sovereign. And, it seems like the president may wish that he was living in England 400 years ago instead of being president of the United States today, because the framers, who were well aware of that history, right, were very clear then to say consists only in levying war against them plural referring to the United States, or adhering to their enemies, giving them aid and comfort. So there's no way that conduct detrimental to the president personally or to other members of the government can possibly fit within this definition. And I think it's safe to say, and again, remember, the First Amendment arguably might compel the same outcome, but the First Amendment wasn't a thing when this was written. And so that's another reason why they had to be so careful in the definition, because they didn't know that they would have the protections of the First Amendment, which might ultimately put limits on what could be prosecuted as treason. And so this only language was critically important at that time. So I think it is safe to say that there is no reputable lawyer, judge, academic who would entertain a treason prosecution based on conduct that might be detrimental to an individual. And it's very important to know, right? I'm sure many of you know this, but some of you may not, that every government official in the United States, federal, military, state, local, takes an oath to the Constitution, right? Not to the president, not to anybody else, but to the Constitution. And so this isn't about the individuals who are filling the position. It's about collectively our government, which is supposed to represent all of us, and that this is really set up as sort of a communal offense. In other words, you are betraying the entire community of Americans, not just an individual or small group of officials in government.
May I follow up? Then is not the Constitution an aspirational document? I mean, in fact, the government is proceeding, punishing whistleblowers as though they are attacking the United States, not misdeeds within the government. I mean, it seems like they're rolling forward on a misconception, misconstruing of these words. And so the Constitution is aspirational. It's not really a thing that the fighter.
Well, yeah, I have to say the whole issue related to whistleblowers is obviously extremely complex and would itself be worthy probably of an entire session like this if folks are looking for extending this into the next year. And I don't mean that facetiously, but I mean it really is something that deserves a lot of careful thought. You know, I'm a bit agnostic. I mean, with respect to the current whistleblower that's in the news, my understanding is that that's an individual, I don't know, I have an idea who it was, but it's an individual who was sufficiently knowledgeable about the law and sufficiently knowledgeable about the intelligence considerations of what was going on, that they were in a position to in fact make an informed decision that law was being violated and there was a statute that addressed essentially how to proceed and provided specific legal protections. And so, you know, I am fully concerned about what the government is doing, and particularly the fact that, you know, the president and allies are trying to vilify that individual. On the other hand, there are people out there that some of you may be very fond of, people like Chelsea Manning, who I think fully deserved to be prosecuted, because this was an individual who just dumped tons and tons of classified information into the public forum with no idea whatsoever what that information was, how much of it actually harmed our national security. You know, I mean, this goes back to the Pentagon Papers. Daniel Ellsberg was the author of those papers, right? He knew what the significance was, and he was willing to take the risks. So I have a great deal of respect for Daniel Ellsberg. I have no respect for Chelsea Manning because she did some real harm to our national security, and I think the government was right to seek prosecution. Many of you may disagree, but so the whole issue of whistleblowers really is, you know, complex. There are some whistleblowers who really know what they're doing, understand that laws have been violated, and they are taking bold action to try to bring to all of our knowledge what's going on and allow the system to correct itself. But there are other people who are called whistleblowers or portray themselves as whistleblowers who actually don't have that kind of knowledge. And there are things that are legitimately classified. I mean, that's certainly one thing I feel very comfortable saying, having spent as much time in the military as I did. And I'm not comfortable having people just spilling that kind of information and harming what is legitimate national security. Now, I'll tell you, because I haven't spent 21 years in the military, I don't see anything going on in the world right now today that I think there's really a military solution to. So I'm not like a pro rah-rah, let's use force everywhere. But I do still think that we do have some fundamental national security interests. And I think to the extent that we're spending a lot of taxpayers' dollars on military systems and diplomacy and stuff, that there is a certain amount of secrecy that needs to be preserved for the effectiveness of those things. And so I want to be a little bit cautious about just always taking the side of a so-called whistleblower.
In the campaign 2016, both Clinton and Trump alleged that Snowden committed treason. What act were they using to justify this treason? Who are we at war against that Snowden would commit treason in the sense that he allegedly did?
Yeah, you know, I don't see it. And that's, I mean, one of the great things right about this is we can be very bipartisan because we have allegations by people on both sides of the political spectrum that people on the other side are engaging in treason, and we ought to insist that everybody, regardless of which side of the political spectrum they're on, look at the law first, look at the facts second and refrain from elevating this debate to going nuclear in this debate by throwing out the treason word, when in fact that I'm not aware of a single situation involving any recent allegation of treason that could actually fit the definition.
Thank you so much. I have a question here. Recently, not so much recently, but a few months ago, I saw a documentary about 4 African American young men who happened to belong to the Nation of Islam. And they have committed, little things, robberies, and maybe belonged to a gang when they were very young. So there was this other man who was informant for the FBI and accused these 4 youngsters of buying and selling arms for terrorists, Boko Haram, ISIS, Taliban. And to make a long story short, they didn't prove it to me that they were, that they were committing these crimes. I got the feeling that they were innocent, and so many others. It was at the end of the Bush administration, beginning of Barack Obama. So these other men who happened to be from the Middle East, who was informant, he framed them. So my question is, how do we know if they're telling the truth? Because many times they're not telling the truth. And innocent people can end up in prison being accused that they're committing these crimes.
No, I mean, that is a very real problem. And since 9/11, the government, I've seen, there are different figures, but the federal government will claim to have prosecuted well over 500, maybe as many as 1,000 individuals for terrorism-related offenses. And the unfortunate reality is that terrorism is such an emotional issue in this country that it really is. I've referred to treason as the T word tonight, but numerically, certainly, terrorism really is the T word. And when the government alleges someone has participated in some sort of support for terrorism, it suddenly becomes very easy to get a conviction because nobody wants to go on record as being soft on terrorism. And so there have been a number of very suspect prosecutions. Another problem really is entrapment. In other words, there have been a lot of government investigative agencies that have sort of hung around, particularly Muslim communities in the United States, kind of with their ears open, and if they think somebody might be the slightest bit sympathetic, government agents in disguise will offer them opportunities to stray from the straight and narrow, and then quick to pounce on them, arrest them, prosecute them, send them off to a supermax prison, and pat themselves in the back for we're so great because we're out here protecting you against terrorism, when many of these folks were not terrorists at all. They were just induced by the government or a friend to do something that was slightly across the line. And the next thing they know, they're facing years in prison. And of course, the irony is, right, it's only treason that even requires 2 witnesses. And so all you need is 1 informant to testify against somebody, and they can be locked away for life in a supermax prison. So we would be naive if we did not think that some of these many hundreds and hundreds of terrorism-related convictions since 9/11 have in fact been misguided, shall we say.
Okay, I'm over here. Right here. Here, right here.
Of course, I was hearing you guys as speakers, so
problem.
it's like I have no directional cues.
I'm interested in the word adhere, what the founders meant by adhere. You went over that briefly, and what we might think of being what adhere might mean in the present day.
Yeah.
Yeah.
So as a practical matter, adhere, I'm trying to think what would be the, ironically, everybody just uses that term, but it really goes to the intent, meaning you have to actually desire to support that entity. You have to see that entity advance its ends at the expense of the United States. So the adhere to their enemies is really the intent requirement, and the giving them aid or comfort is really the overt act requirement. So
Okay.
you have to both want to see that entity succeed against the United States, and you have to actually do something that is a step towards providing them with actual support.
Okay, to follow up on that, and I hope I'll be brief. Adherence can be implicit rather than explicitly stated. It is really the intent which may manifest itself in behavior, but we can't divine it to begin with.
Yes, so exactly. So the courts, it's very easy, obviously, if if the government is able to find your diaries or maybe your Twitter posts or something in which you actually express support for the other side, right? That won't be sufficient for conviction, but that would be sufficient to demonstrate that you adhered or supported them. But you're absolutely right. The government, there's Supreme Court cases which say that this can be proven essentially circumstantially. So the government could, for example, demonstrate what you had done and argue to the jury that you would have only done that if, in fact, you supported the other side. And so the adherence can be proved circumstantially without having to have someone either introduce evidence, your own writings or something which show that you support them, or the testimony of witnesses. Well, I heard him hanging out on the street corner saying that he was going to do something to support Nazi Germany. So, of course, when he helped his son get his job at the defense plant, that was in support of Nazi Germany. You can again infer that from the conduct potentially. Now, again, the idea ultimately, right, the protection for us is supposed to be the need to persuade 12 jurors that they should unanimously convict. So, we would hope, it doesn't always happen, of course, but we would hope that the government would have a reasonable burden of proof to meet, and that a jury, quote, of peers, right, would question allegations. But again, one problem with treason is it, again, so sensational that government probably has gotten a lot of benefit of the doubt in those prosecutions that have happened historically.
Were any Confederate soldiers convicted of treason from the Civil War?
So excellent question. And something I actually thought about initially trying to include in the presentation, right? Because the whole Confederacy absolutely was a classic example of treason, right? You are forming a large conspiracy, essentially, putting together, mustering initially tens and eventually hundreds of thousands of men in arms to fight the government of the United States. And everybody who fought for the Confederacy, or almost everybody, everybody who fought for the Confederacy was either an American citizen or was present in the United States, right, and was therefore benefiting from the legal protections of the United States and therefore owed at least temporary allegiance, to the United States. So this was potentially a classic case of treason. Now, the United States, as a matter of law then, had every right, if it wished, to treat every Confederate as a traitor. And we could have, after every battle, we could have taken all of the captured Confederates, slapped them into prison, prosecuted them for treason, and executed them if we wanted to. And that would have been perfectly legitimate. Why didn't we? Well, who won the first battles of the Civil War? The South. Who had all the prisoners? The South, right? They had lots of Union soldiers in prison. We had a comparatively small handful of Confederates, and very quickly people in the North said, we better treat the Southerners as legitimate belligerents, give those guys we capture prisoner of war status in order to be able to demand that they do the same for ours. Now at sea initially, the Confederates didn't have a navy, and so they sought to field privateers, which was perfectly, well, the rest of the international community had outlawed it a few years before, but the US, to its great regret, had refused to go along with it at the time. So the South said, hey, great, the US says privateering's legal. We can give letters to Southerners who can then use the letter as authority to outfit a privately owned warship and go wreak havoc on Union shipping. And so they started doing that. The US was totally vulnerable because the North had billions of dollars invested in whale ships and cargo ships and stuff, and the Confederate was snatching these things up right and left. And so the first couple times the Americans captured Confederate crews, they decided to put them on trial for piracy. And the Confederates said, fine, you execute one of those guys, and we're going to start executing prisoners of war. And the US said, oops, maybe we don't want to go that way. And so ultimately, de facto, we conferred belligerent status on the entire South. After the war, there were actually plans to try Jefferson Davis for treason, and he was actually held in prison in Virginia for an extended period of time. But ultimately, after the death of Lincoln and Andrew Johnson's president, who has sort of pro-Southern sympathies, that essentially just died. But to this day, now I went to high school in Northern Virginia, so I kind of, see both sides. But to this day, I cannot understand how we as a country have allowed this dialogue to persist, that somehow the Southern folks who launched this terrible rebellion somehow are deserving of having statues maintained in their honor. Pardon my language, but they're fucking traitors.
Bravo.
Every one of them. Why do we honor them? I don't get it. And why do we let Southerners get away with saying that the war was about states' rights? Right? The first state to secede was South Carolina, right? Every American needs to read the South Carolina Declaration of Secession. Correct. It makes it 100% clear that the South was fighting to keep blacks enslaved. That's why they were fighting. It wasn't about states' rights. It was about African American slavery. And to let people get away with flying Confederate flags today as if this was just the symbol of some loyal Americans who had a different interpretation of the Constitution with respect to states' rights and the right to secede, it's bullshit, pardon my language. But anyway, there's treason en masse, and yet we don't acknowledge it as a society.
I guess I'm over here. I'm a great peruser of commas in the Constitution, and I've reread this treason clause over and over again since this last round of things that have been happening in the media. Treason against the United States shall consist only in levying war against them or in adhering to their enemies. So if you skip the way the sentence is constructed, again, it's 18th century English. Treason against the United States shall consist only in levying war against them or in adhering to their enemies. So it looks like this is at the same level in grammar as the first subjunctive clause there. Treason against the United States could be just adhering to their enemies. Is this, and you're saying you're disagreeing with this interpretation. Is that what I am understanding?
Yes. No, I absolutely, and the irony is that for some clauses of the Constitution, sort of the way that we do interpret them is looking to things like the punctuation. And I absolutely agree that as a matter of pure linguistic logic, there doesn't seem to be any way to distinguish between those. And so what should have been done, most likely, and I'm not a grammarian, but I think that there should either be a semicolon after against them to make it clear that that is a harder stop or break than between adhering to their enemies, comma, given made, or that the comma after enemies should probably be have been replaced with and or something like that so that we don't have that same comma. That said, I really feel 100% confident that the interpretation I've offered you is the correct one.
Based on the Madison Papers and English
based
law.
on the wording of the British statute, based on the speeches given in Congress at the time that this was being, or the Constitutional Convention at the time this was being debated, based on the writings of all of the American judges who have considered this since then, including multiple Supreme Court cases. Every one of those has endorsed and is the reason why I explained it the way I did. So it's not like this is sort of my opinion
Yeah.
and there's a dissenting view out there somewhere. But you're absolutely right. From just a literal reading of it and examining the punctuation, it doesn't seem to say what I said it does.
The reason I'm bringing this up is many years ago I had a conversation with a very elderly grammarian who specialized and lived in his mind in the 18th century. And to him, the reading of both the Second Amendment, and I think this is very, to him it was very clear, because we were specifically talking about the Second Amendment and that infamous comma. And to him, based on his reading and breathing this 18th century English language, that comma about the well-regulated militia and an individual's rights is completely been misinterpreted by the Supreme Court, by Scalia and whatever. And looking at the way he interpreted that, and looking at this, it's almost the same situation. And I'm reading it as treason against the United States shall consist only in or adhering to their enemies. And I personally, my background, I'm connected to Russian culture in a sideways way. My ethnicity is subjugated and being suppressed by the Russian government. My family suffered under the communists and under the Russians severely. I've paid attention to what's going on in Russian military circles as well as government circles and cultural circles with the Orthodox Church, Putin's grand allegiances with different people, his different enablers. And I don't agree with that old adage, that came out of the 60s, somebody gave a war but nobody came. We are in a war ideologically, politically, economically against a state actor, whether it's a declared war or not. We have to acknowledge that, and we have to recognize that, and to say that somebody in high office is not adhering to an enemy here, that's ignorance, and I think that it's fatal to us.
I mean, we want to have a discussion, so that's great. I certainly don't, I'm not sure, for example, so changing the subject a little bit, but the impeachment clause, as I mentioned, uses the term high crime, does use treason, but it has a separate category of high crimes. And a high crime is an offense of disloyalty, to the United States, or betraying our trust or something. Now, impeachment is another area in which we don't have a whole lot of experience. We don't have a whole lot of case law. But so far, the courts seem to suggest that Congress has a great deal of flexibility in deciding what constitutes a high crime or misdemeanor. And now, since the election of President Trump, the government his administration has had incredible success in getting judges confirmed. While we had a Democratic president, the Republicans did an amazing job of slow rolling the confirmation of judges. But during the Trump administration, we have seen just the floodgates open. It's very ironic, for example, right now, the Ninth Circuit, the largest of the federal circuits, has this incredible reputation particularly among conservatives, of being a bunch of liberal flight crackpots. But the Trump administration has gotten to appoint a lot of judges to this court. And so there are not going to be the same kind of liberal decisions coming out, or at least not from many of the panels that will be constituted, as we've seen in the past. Very, very different situation. And so I believe that we're seeing a number of politicized court decisions come out. I mean, the courts have always, to some extent, been politicized. And so I'm not confident that things that I say today will actually be the outcome of Supreme Court cases 2, 3, 4 years from now. But based on prior Supreme Court and federal practice, Congress has a great deal of authority, again, to decide what is an impeachable offense. And so I feel very comfortable telling you that based on the historical legal understandings, this crime of treason is very limited, and we should linguistically read it as if it's a semicolon after them, and so the comma between enemies and giving them aid and comfort doesn't break this up into 3 categories of treason, but to suggest that if you really believe that a leader of the United States has engaged in disloyal and harmful conduct, that a more productive approach would be to try to persuade your congressperson that they should define that conduct as a high crime qualifying for impeachment, even if it doesn't qualify for a criminal prosecution.
We'll get the microphone to you, but I actually had a question, but afterwards we'll get the microphone to you. I'm so intrigued by this idea of broadcasting during World War II, and the 2 broadcasters you cited were prosecuted for treason or tried for treason. And I know there was a question earlier about that, but I can't help think of militia groups disseminating information to overthrow the government that on websites, and I know they're acting independently. We're not in a war, but this is militia groups whose mission is, if you read some of these, is to overthrow the government. So, is that free speech or is that treason? Or
well, so the first thing I would say is, and I'm not a prosecutor, and I have not really researched the federal criminal code, but I would suggest that there is a lot of middle ground between free speech and treason, and a lot of potentially applicable statutes. The United States, for example, has very broad conspiracy laws, which most other countries in the world don't. So in other words, if you get together with 1 or more people and make plans to violate or encourage people to violate an actual criminal statute, it's relatively straightforward to prosecute you for the crime of conspiracy. And so even if some of these hate groups don't rise to the level of becoming enemies of the United States, or their conduct may not rise to the level of levying war, if they're arguing that you should go out and kill a low-level federal official or fight the National Guard or something, that doesn't have to rise to the level of treason to be prosecutable as criminal conduct. And so I think that's something that we should keep in mind. I mean, the framers really believed that treason was, this very, very serious crime. I read you stories, concerns about just allegations of treason and stuff. So we don't need to think that conduct that we find reprehensible or concerned about ever needs to rise to the level of treason. A competent federal prosecutor could find all kinds of middle ground statutes that would allow prosecution without having to meet this test and without having to cause all of the public disruption that would happen over this being a treason prosecution, and the press, even if the press was not sympathetic to the cause, that people are going to say, well, we haven't prosecuted anybody for treason in 50 years, and it's not necessary, I would say, for a lot of things we're concerned about, and particularly not necessary to demonstrate that a president has engaged in treason if you find reason to be concerned about their conduct and think that, and please, I'm not trying to offer an opinion on this, but I mean, if if people really believe that a senior executive branch official has engaged in conduct seriously detrimental to the welfare of the United States collectively, then it is quite possible that Congress can find that to be an impeachable offense without ever having to get to this level.
I have a question. I'm really very concerned about this impeachment. We only have 1 year ahead, and I think the Democrats are going to win easily. There are at least 3 very strong candidates. So my concern is that, and that's the question, do you think this impeachment could backfire? And because I'm hearing some Americans saying, I'm not going to vote Republican, but I don't see a true agenda by the Democrats. I'm going to stay at home. So I'm very concerned about that. Don't you think that maybe this obsession with impeachment, that the Republicans did it with William Jefferson Clinton before, could backfire?
So,
We're going to stay tuned because one of the coming Constitution happy hours will be addressing impeachment.
oh, okay,
So
great.
off the hook.
Oh, but you asked for my personal opinion, right?
Yeah,
So-
you're welcome to share
So
the
I can
personal.
opine, right? Now, let me be clear that I am merely opining here, and so my opinion is no more valuable than anybody else's in this room, so I do want to be clear about that. But since I was asked, my personal view is if the Democrats were smart, they would impeach the Attorney General and not the President. Because the Attorney General has been up to his neck in this. The Attorney General obstructed whistleblower investigation, even though the law was very clear that Congress was entitled to the information as a matter of law. And who the hell in this country gives a rat's ass about Bill Barr, right? I mean, you could impeach him, use that as a vehicle to surface all of the dirt about what the administration had been done, and avoid alienating the president's base and energizing them by going after a guy that they love, go after a guy that nobody cares a rat's ass about, right? And accomplish much better. That would be my recommendation if any senior Democratic or congressional official asked me how to proceed. As I do see a very real risk, right, that just politically targeting the president just raises the hackles of his base and may not be a great strategy. And who knows if at the end of the day, and you're not going to impeach him without some serious, you can impeach him with just a majority vote in the House. So the Democrats could do that without Republican support, but you can't do anything serious in the Senate without significant Republicans coming along. So it's just going to, I think you're right, there's a very real risk of it just being perceived as vicious politics if you don't actually have a lot of Republicans who believe that they should be removed from office. So I'd go after the Attorney General if it was me.
So there's a question here, and I'm asking on behalf of one of our audience members about Snowden.
So what about Snowden?
Yeah, what about him?
Would he be convicted of treason?
Well, it'd be very difficult. For one thing, right, again, we have this very narrow definition. So no problem whatsoever, I think, convicting. I mean, again, remember I said we have this broad range of federal statutes. So we have a whole bunch of espionage crimes, a whole bunch of crimes related to deliberately either wrongfully possessing classified information or disseminating classified information. And so it's very, very easy for the government to prosecute Snowden and sentence him to a pretty long term of imprisonment if they get their hands on him and they want to. I think treason would be very much overreaching because I don't think you could show that he had the intent to, he thought he was a whistleblower, right? His intent was to make Americans aware of what was going on in their government. It'd be very difficult to demonstrate that he had the intent to do the harm required for treason. and also could be difficult to demonstrate that he was actually aiding any entity that qualifies as an enemy of the United States. So I think a treason prosecution, very, very difficult. I think other federal crimes, almost open and shut.
I guess it's me. I'm unclear, and I'd like to know I am unclear. What happened to separation of powers when we have the executive, legislative, and judicial branch? And where does William Barr come in with the separation of power? I don't see it. It seems to me they're one and the same, the executive and the attorney general.
So the Attorney General's in a very complex situation because technically, the way the government is structured, the Attorney General is a member of the executive branch, right? He's the head of the Department of Justice, which is a cabinet agency, just like all of the other cabinet agencies. The Attorney General is handpicked by the President, nominated, confirmed by Congress. Historically, however, the role of the Attorney General has always been viewed as being somewhat different than the other heads of department. And the Attorney Generals have almost all believed that they owed a duty of loyalty to the law and to the United States rather than to the President personally. And so the Attorney General has traditionally been understood to be in a unique role of trying to see ultimately that the law is served as much or more than that the President gets to do what they want to do. For the first, probably almost 150 years of our history, every time that the administration had a serious legal question about whether it could do something or not, they would turn to the Attorney General, ask the Attorney General's opinion, and the Attorney General would write a candid and detailed explication of what they thought the law required, and the executive branch would generally follow that. When we got to the early 20th century, the government grew so large so fast that no one person could do that anymore. And so they established within the Department of Justice an office known as the Office of Legal Counsel, or OLC, and their job was to do the same thing, that any time part of the federal government had a legal question, Congress passed a statute that said the government will do X, but the Department of Energy isn't really sure what X is supposed to be in this particular situation, or they want to do something and not really sure if it's constitutional. So they would pose the question to the Office of Legal Counsel, and that opinion was understood generally to bind the executive branch. Now, most of us never heard of the Office of Legal Counsel. Well, first of all, a lot of Americans aren't aware that there are actually historical volumes of these opinions of the Attorney General that were published and available to the public and are still available online for anybody who wants to look at them. But these Office of Legal Counsel opinions, many of those are also published or available online, but most people had never heard of that office until in the second Bush administration, they wrote a couple memos which basically authorized the US government to engage in torture. And as those memos got leaked to the public, the Office of Legal Counsel sort of got on the public radar for the first time. But again, it highlights the fact that they can be perverted, but it also highlights the fact that senior members of the Justice Department are supposed to be more than just partisan supporters of the president. They are supposed to actually seek to enforce U.S. compliance with the law, which again is the reason why I personally would prefer to see the Attorney General impeached, because I think he has failed to uphold those standards, and I think that is an impeachable offense.
So does that constitute conflict of interest? That's the way it looks to me.
It is sort of, and that's why the president has I don't say always, because I don't know where the practice actually began historically, but certainly for most of the 20th century, the president and the vice president have had their own lawyers within their office. And the idea would be, in theory at least, that if the president really wants to know if they can push the edge of the envelope on something, they talk to their own lawyer, because the Attorney General is understood to not really be the President's lawyer, but really to be all of our lawyer, and represent the Constitution and the laws, rather than be an individual who's supposed to help the President figure out how to accomplish their partisan purposes.
Ergo, it doesn't happen today.
Really good question.
Can you please repeat the question?
The question is, can we have a single impeachment act, right? In other words, could you impeach the President and the Attorney General at this, in one package? I'm inclined to think that it has to be individual, but I don't know why you couldn't have sort of common articles and vote them against the President and vote them against the other individual, in this case the Attorney General, and then why the Senate gets to make its own rules as far as how to conduct an impeachment trial. The only thing that's required is just that if the President is being tried, the Chief Justice is supposed to preside over the Senate while the President's being tried. But I don't see any reason why the Senate couldn't then decide that there are so many common facts here that we're going to essentially have hearings on both at the same time, and then again would just have to vote individually on whether to remove each one individually from office. So I think you could. I can't think of any reason why you couldn't package them together essentially for processing, but I do think you would have to have individual articles of impeachment against each, even though they might say the same thing.
Well, these are fantastic questions to go out on. Before we all leave, I want to remind you that there are voter registration cards, and if you know people who are under 18 years old, they can pre-register to vote now, so you can give them a voter registration card anyhow, and there's information about that on the table. We also have the citizenship naturalization test on the table, if you'd like to see if you would pass that test. I, for one, know already that there's no way I would pass. There's also a fun quiz of your knowledge of the Constitution and some other information, including upcoming Hammer public programs. If you did not get a copy of the U.S. Constitution, we'll give you a paperback copy. Just let the ushers know. And I don't know about everybody else, but I personally learned so much tonight, and I feel like if I ever am confronted, I can argue this. So please let your friends know. Hopefully you'll all come back. We have 5 of these nights planned. And please thank Linda Pollock and, of course, Dave Glazier for speaking.